Hello, everybody. This is another episode of Upfront with me at Leaflet. Today, we have two very distinguished guests, two noted jurists, former judge of the Supreme Court of India, Justice Lokur, who headed the social justice branch of the court for many years, and is one of the rare judges who has been very vocal and vociferous on the issues of human rights, civil liberties, and judicial activism. And we have Indira Jaising, again, a very noted human rights lawyer and former Additional Solicitor General of India. Welcome to Upfront program at the Leaflet, Justice Lokur. I would like to start with you, Justice Lokur. Since you retired, have been writing a series of papers and articles on the issue of civil liberties and fundamental rights. And it has been a concern in our country increasingly over the last few years, the way the state has been suppressing freedom of speech and has been denying civil liberties to many people who have been incarcerated on supposedly, seemingly flimsy charges. You wrote a recent piece. This is in the wake of the Delhi High Court judgment on Natasha Narwal, Devangana Kalita, and Asif Iqbal's bail application, where the Delhi High Court interpreted UAPA in a certain way before giving bail to the three student activists. And you pointed out 5 questions. So I'd like to start with that, Justice Lokur. What is your biggest concern with the way of the Delhi High Court interpreted UAPA, and then following which the Supreme Court had stayed the order, practically stayed the order?
Yes, thank you, Ashish. First of all, I just want to clarify that I have not commented on the judgment of the Delhi High Court. In fact, I've said that in the first paragraph itself, that I'm not making any comment on the judgment of the Delhi High Court. I was only concerned with the process that was involved in the initially refusal of bail by the trial court. But as far as the interpretation of the law is concerned by the Delhi High Court, you have to go back into the provisions of the UAPA. And while doing that, you have to go back to the provisions of TADA, Terrorist and Disruptive Activities Act, POTA, Prevention of Terrorism Act, and then comes UAPA. Essentially, I believe that bail is a matter of right. It's not a matter of discretion for the judge. Of course, the judge has to also use his discretion, his or her discretion in granting or refusing to grant bail and imposing conditions. But it's really a matter of right, which right can be curtailed or stopped on the basis of submissions made by the prosecution. Now, if you look at it from that point of view, under TADA, it was said that was the first law, 1987. They had said that bail can be refused if there are reasonable grounds for believing that the person is not guilty of the offense. Okay. Now, how do you say that a person is not guilty of the offense? The person who is accused of the offense will say, listen, I'm not guilty. All right. Now, the public prosecutor has to be heard. He will say he's guilty. So the court will have to see why the public prosecutor is saying he's guilty. It will also have to see why the accused is saying he's not guilty. So there will have to be this, arguments back and forth, so to speak, that the court will have to look into and then come to a conclusion that I think that there are reasonable grounds for believing that this person is guilty. In POTA, it was more or less the same, right? Except that instead of reasonable grounds for believing, they said grounds for believing. Okay, but really that doesn't make much of a difference because it still has to be reasonable. Grounds for believing that he is not guilty. Now, if you look at it in that light, under UAPA, the bail provision says reasonable grounds for believing that the accusation is prima facie true. Okay. Now, in all three statutes, both the sides have to be heard. Otherwise, an accused will say that, listen, why are you hearing the other side? I'm telling you I'm not guilty, and these are the reasons I'm giving you why I'm not guilty. Don't hear the other side. But that would be a very strange sort of a situation. So similarly, under UAPA, if the prosecution says that, listen, I think there are reasonable grounds for believing that what I'm saying is prima facie true, the accused can say, listen, this public prosecutor is not giving the entire truth, or there are no reasonable grounds for believing that what he is saying is prima facie true. So there has to be a hearing of both the sides. And this is something which has been acknowledged by the Delhi High Court. And the Delhi High Court has then come to the conclusion after hearing both the sides that, listen, we don't think there is any evidence against this person. And therefore, prima facie, we don't think that there is any ground for believing that the accusation made is prima facie true. That being the position, the provisions of UAPA are not retracted, and therefore the persons are entitled to bail. So it's it's a sequence that has been going on since 1987, and I think the conclusion of the Delhi High Court is logical in that sense.
But besides the bail provisions and where you explained the process involved in disposing of the bail applications of the accused under the UAPA Act, you have also raised questions about the police process, in the sense that how the charge sheets were not delivered on time, how the physical charge sheets were not given or were perhaps deliberately denied, and even the registration of multiple FIRs. Some of these FIRs seem to be more tactical. You also highlighted that how when accused got bail in one FIR, they were arrested in the court at the very same time when they were bailed out in the earlier FIR. And even when they were bailed by the Delhi High Court, that order was again forestalled, which means that the Delhi police said that, look, we have to verify the addresses. So they all in culmination, Justice Lokur, it seems that there was a witch hunt against these student activists, and which you have highlighted. And this witch hunt doesn't restrict to this case. It has been going on in various other cases as well, which is the way the sedition law has been applied, the way the right to protest peacefully has been denied. And an MP recently was arrested under Sedition Act and Sedition law, and was also tortured during police custody. So is there a pattern in the way the state has been acting against those it believe are ideologically opposed to its stance? Do you see a pattern?
I'm not sure whether it's only ideological, right? It's a question of disagreement also, in the sense that I may have the same ideology as a particular person, but I don't agree with that person, or I don't agree with the policies of that person or the views of that person, even though the ideology may be the same. So it's not really so much ideological as a general pattern that if somebody does something wrong, let's fix that person, kind of thing. That famous Thokdo kind of attitude. that is what is a little troubling.
Right. I would come back to this point that you just raised, that this approach of Thokdo is becoming a norm and the default rule by which the state is playing. But before that, I'd like to ask Indira one question. Indira, you have been representing the Bhima Koregaon accused before the courts. What is your interpretation of a terrorist act? Because while deciding the bail application of the 3 student activists we just spoke about, the Delhi High Court had to go into the definitional issues. which is section 15. What is the terrorist act? Whether there was a prima facie case of terrorism. According to you, what is terrorism? Is inciting a riot an act of terrorism?
Ashish, I will also preface my comments with a caveat. You point out that I am representing some of the accused in the Bhima Koregaon case, and the matter is sub judice. So I will not refer to the facts of that case. However, you know that worldwide, we don't have a standardized definition of what is terrorism. All we have is what is a terrorist act. Now, I would, however, like to put on the table my definition of terrorism from a reading of international law. At the heart of the issue of terrorism is intimidation, an act of intimidation. So, what is terrorism? It is intimidating the government to do or not to do something, the impact of which is felt by ordinary citizens of that state, ordinary citizens of India, I would say. For example, you might say that the hijacking of the aircraft at Kandahar was an act of terrorism because demands were made, release so-and-so, 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 and failing which the aircraft will be blown up. So that would be a classical case of terrorism and a terrorist act. However, my approach to the question that you raised is to look at the plain meaning of the section. Now, I would like to draw your attention to the plain wording of section 15 of the Unlawful Activities Prevention Act of 1967. And this is what it says. Whoever does any act with intent to threaten or likely to threaten, now please listen carefully to these words, the unity, the integrity, the security, the economic security brought in by an amendment by the UPA government, or the sovereignty of India, or with intent to strike terror or likely to strike terror in the people or any section of the people. Now pause here. As intelligent thinking people, we know the distinction between an act which threatens the unity of India, the integrity of India, the security of India, and the sovereignty of India. Granted, there is some ambiguity about the use of the word sovereignty, but in my opinion, it is used here in the context of unity, integrity, and it's probably meant to refer to territorial sovereignty. What I have noticed in actual practice is that this section is invoked in the case of an ordinary act of violence. By the way, the section also requires to be a terrorist act the use of deadly weapons, which cause death or are likely to cause death, etc. Now, what I've found is that looking at the cases that are registered in India, I have found that none of those even state in the FIR that there was an attempt to attack or threaten the unity or integrity or sovereignty of India. The problem, I think, here is the way this law is being interpreted by the police, the prosecution, the decision makers, is that they collapse the difference between government and India, right? As Justice Lokur pointed out, you may disagree with the policy of the government of India. You may dissent. You may oppose. You may protest. It doesn't amount to an attack on India. And I think it's very important for us to make that distinction between an attack on India and an attack on a policy of a government. Otherwise, we are liable to end up in a situation where you say the government is India and India is the government. Or you say a particular individual in the government is India and India is that one individual. So we really need to distinguish between the two. And I've been saying for very long, every riot is an offense under the Indian Penal Code, but not every riot is an act of terrorism. This is the essential difference that we need to make when we are looking at laws.
Right. So fine, but there are riots, and then there are organized riots. So what if there are organizations who, by sloganeering, by organizing meetings, by giving call to people to arms, first create an environment of communal disharmony, communal discord. They give a call for a bandh, and then they organize their cadres. They distribute arms and weapons to them, and then they raid a particular neighborhood and they kill more than 100 people. What is that?
Yeah.
This is not an ordinary riot. This is a very organized riot, and it strikes terror in the people. Is it not terrorism?
Yeah, so Ashish, rather than talking abstractly, I think we need to refer to real life situations
No,
which
I,
have
I- I'm,
occurred
I'm,
in.
I'm talking to real life situations. So suppose Naroda Patia in 2002,
Yeah.
we saw
Yes,
that we have now convictions both by the trial court and also by the high court. Convictions
yes,
have been upheld by the high court.
that's right. So I will, yes, so
So
when I,
if I can just refer to the trial court judgment, where the judge actually uses the word terrorism while convicting them, and says that they struck terror in the people. So
yes,
is that not terrorism?
right. So when I was referring to real life situations, I really wanted to come back to the some of the most recent, what we have come to describe as pogroms. We don't even call them riots anymore. And there is a debate in the public domain that you don't even call it a pogrom, you call it genocide. Okay, so we know what happened in 1992, post the demolition of the Babri Masjid. We've also seen Gujarat 2002, and I would say that yes, those are cases where uh, your Section 15 of the UAPA Act could have been invoked, but
And
was
also
not.
1984 riots.
That's
And
right.
yeah.
That is right. 1984 as well. I would say that those are cases where Section 15 of the Act could have been invoked, but was not invoked. And so that brings you to the question, how come this act is not invoked in a situation like that, whereas it is invoked for somebody like Disha Ravi or Natasha or any of the recent cases that we've seen? Yeah. Now, so the only conclusion I can draw is that prosecution in this country is a political act. And let us not forget that who launches the prosecution, right? Who launches it? It's the police. And who is the police accountable to? The police, at the end of the day, in this country, is accountable to the Ministry of Home Affairs, right? So, although the Ministry of Home Affairs cannot interfere with an investigation, that's the law, but the act of invocation itself of a particular law becomes a political act. And in that sense, I think we are seeing um, an ideological use of the law.
Right.
Justice, you asked the question, and Justice Lokur responded, but
Yes.
it is an ideological use of the law. I can give you examples, but they're sub judice. In the case of Bhima Koregaon, I have raised the issue in my petition of what we now call selective prosecution. Why go to Bhima Koregaon? Let's have a look at West Bengal. The Sudhendra Adhikari and Mukul Roy were not prosecuted in relation to the same Narada scam, for which sitting ministers
Yeah.
of the West Bengal government were arrested. So this is an act of selective prosecution, which is violative of Article 14 of the Constitution of India.
I'd like to go back to Justice Lokur. Justice Lokur, Indira pointed out by giving various, real life examples about the political misuse of laws. And all laws are susceptible to misuse, some more than others. There is a user law theory, which is that you give any law in the hands of the police and you show me the man, I will show you the law. But this is where the role of the judiciary becomes very, very important, especially in the case of national security legislations and anti-security, anti-terrorism laws, the way they are applied. So sedition, Waging War Against the Nation, Preventive Detention Act, earlier TADA, POTA, now UAPA. What is, according to you, Justice Lokur, the role of the judiciary, especially the role of the magistrate, the role of the lower judiciary, when dealing with these cases where prima facie there appears to be an abuse of law?
Well, I think the judiciary has to be alive to situations. Okay, it just can't. I don't accept that ivory tower theory at all. The judiciary has to be alive to situations. Now, you have grades of offenses. All right. Worst offense, if I may use that expression, is terrorism. All right. Then you have something a little lower down in the ladder. Under the UAPA, you have something called an unlawful activity. Unlawful activity has been defined as sovereignty, integrity of India, and secession and secession. Then you have IPC offenses. All right. Now you have sedition, for example. Sedition talks about causing, exciting, or tending to excite disaffection against India. That is sedition. Now, in one of these statutes, I think it is, it's in UAPA, causing or intending to cause disaffection is an activity which amounts to terrorism. It's an activity which amounts to unlawful activity under the UAPA. Okay, so now you have the same act. The same act can be, a person can be prosecuted under the IPC for sedition, 124A. That same person can be prosecuted under the UAPA for an unlawful activity. Punishments are different. Provisions are different in terms of bail and so on. But the offense is the same. The definition is more or less the same. One uses the word exciting, the other one says causing. So the judiciary has to make that distinction. And this is one of the distinctions which the Delhi High Court has made, in a sense, where they say that, listen, if it can be done under the IPC, prosecute that person under the IPC. Why do you have to go to UAPA? All right. So because UAPA is a much harsher provision in terms of punishment and so on, don't use that, if the same result can be achieved by IPC. But if you think it is something, much greater, now in this case, much greater would have to be terrorism, So unless you equate sedition with terrorism, you proceed against a person for sedition under IPC. If it is, of a nature which perhaps comes in the definition of unlawful activity. I don't, offhand, I can't say what would come under the definition of unlawful activity. A seditious act, which would come under the definition of unlawful activity, then you proceed under UAPA. Not that because I have the power to proceed under UAPA, forget about IPC, I'll proceed against you under UAPA. That distinction has to be made and appreciated by the judiciary. Because you are not dealing with an ordinary case. You're not dealing with an ordinary person. The case is one of terrorism or not of terrorism. Right? The person is a terrorist or not a terrorist. You're dealing with the life and liberty of that person. Supposing he is not a terrorist and it's not a case of terrorism. And you put that person behind bars and say, all right, I'm throwing away the keys. The consequences are very serious. That is the difference which I think the judiciary should appreciate.
Right. So, Justice Lokur, this has been a perennial problem, which is of misuse, abuse, misapplication of anti-terror laws right from the mid-80s, since we had TADA in place, then came POTA. It is well documented, Justice Lokur, that both under TADA, then under POTA, and now under UAPA, a large number of people who are detained and prosecuted eventually get acquitted. Now, the question still remains after 3 decades of our lived experience with special, extraordinary anti-terror laws. How can we achieve sufficient judicial oversight of police and prosecutorial decision making? Why that question still remains at large, and what can the Supreme Court do to ensure that there is enough accountability and enough, as you pointed out, that the lower judiciary is alive to the situation?
You see, the Supreme Court has said in Prakash Singh's case long time back that there must be separation between the investigation and the prosecution, right? Not implemented. All right, that's one. The second thing is about the judiciary being alive to all this. Now, yes, there is misuse. Yes, there is abuse. But what about National Security Act? That is also being abused, right? Today in the newspapers, I found a very strange write-up. Madhya Pradesh High Court set aside the preventive detention of a person because he was selling oximeters at an inflated price. Right now, I don't know how much an oximeter costs, maybe 1,000, 2,000 rupees. He couldn't have been selling it for 1 lakh or something. People are not so stupid. He must have been selling it for 2,000, 3,000, 4,000, whatever it is. He may have sold hundreds of them. Is that a question of national security? Right? So, when you have these laws and they are abused, the judiciary has to come hard on the abuse. Nambi Narayan, right? The court said, Supreme Court said, listen, you pay cost compensation. Okay, 50 lakhs, I think.
He'll ask me a question.
Now, in a situation like this, or this oximeter thing, the fellow was in jail for about 50 days. Yeah. Why can't the court say, all right, so what kind of a bogus preventive detention order you have issued? Pay costs. Now, unless the court comes down heavily on the abuse of the law, I'm not saying misuse, because misuse, there can be different views. The trial court thinks it's a misuse, high court thinks it's not a misuse. Judgments can be reversed. But abuse is pretty clear.
Right.
So there, I think the court should come down and tell them what is all this going on.
Right.
And you pay costs, compensation costs, whatever.
Right. Ms. Jaising, I would like to ask you, Justice Lokur has very eloquently spoken about that how each of these cases need to be more effectively, expeditiously dealt by the judiciary at various levels. From your experience as an additional Solicitor General, do you believe that state can prevent terrorism while also simultaneously guaranteeing human rights? Or must the police and the state trade off some human right protections to effectively prevent or punish acts of terror?
Okay. Look, that will be the end of the rule of law, the so-called trade-off. Yeah. So I think it's very important to say it loud and clear that what we are talking about here is the protection of the rule of law, the equality before law and equal protection of laws. So equal protection of laws means whether you're a terrorist or whether you're a saint, you're entitled to the same protection of the law. And therefore this trade-off, yeah. But I can tell you, you wanted my experience as an ASG. Let me tell you, as an ASG, I was handling a lot of cases on behalf of the CBI and prosecuting people against whom cases had been filed, including police officers. And I can tell you that in the Surabuddin case, which is more than famous, notorious as a case in this country, I've heard counsel get up in court and argue, my lord, we should be thankful. By the way, on behalf of the accused police officer, these comments are made in court. My lords, we should be thankful that a dreaded criminal has been done to death. We should not be prosecuting the police officers who have done them to death, even if it was done extrajudicially. Now, what amazed me is that a submission like that is made in the highest court of the land, and the judges listen, keep silent. I don't know what goes on in the minds of judges, so I'll leave that comment over there. But Ashish, I would like to say that our disappointment often is with the highest court of the land, that is the Supreme Court of India. We have noticed in the recent past, high courts have been giving judgments which you could characterize as within the bounds of rule of law and therefore progressive. For example, I am deeply disappointed by the fact that the Supreme Court said, while admitting the appeal against the judgment of the Delhi High Court, this will not be treated as a precedent. Now, I have a comment to make on this. I would have welcomed the admission of this appeal, because we would like to see that interpretation endorsed by the Supreme Court of India. And it is not my case that this appeal should not have been admitted. You know, the race against time to get these people released on bail. And I fear that if they were not already out, then the Supreme Court may even have had the opportunity to stay the operation of the bail order. But that's just speculation. What is on the table is an order which says it shall not be treated as a precedent. Now, you know, in law, it is only a judgment given under Article 142, where the Supreme Court exercises extraordinary jurisdiction to do complete justice, that they can say, in the facts and circumstances, this will not be treated as a precedent. All other judgments of any court, including a constitutional court, which is a high court, and a Supreme Court, no one, not even the Supreme Court, can say it shall not operate as a precedent, because a precedent operates of its own force. It doesn't, it is not binding. The only question is, what is the binding value of a precedent? A judgment of the Delhi High Court will not bind any other high court in the country. They can use it as a persuasive judgment. But to say that this cannot even be cited in another court, it shall not be treated as a precedent, I think goes beyond the four corners of the law. So therefore, we are disappointed. And what really matters is judgments of the Supreme Court, because they operate as the law throughout the territory of India under Article 141 of the Constitution of India. So we do. You did ask the question to Justice Lokur earlier, that what can we do about a magistrate who refuses to read the plain text of the law and say, look, this is not an offense under UAPA. But my question is a bigger question. My question is, what do we do? The answer to that is only the Supreme Court can correct what we call subordinate courts. And therefore, we should focus our attention on what the Supreme Court does and doesn't do.
Justice Lokur, I'm again going back to one of your articles where you wrote about the rule of law. And in that article, you wrote about the culture of impunity. And you said, confidence of the police that its conduct will not be inquired into leads to a culture of impunity. Now, when the police over and over again in cases gets away with blood on its hands, or gets away with the stifling of whether free speech or civil liberties, you think that this is leading to a state of affairs where there is terror in the hearts and minds of the people who don't necessarily agree with the government of the day, and this will eventually erode not just the rule of law, but it will also eventually erode the very democracy of which we are so proud of?
Yes, you see, it's like this. It's actually not only the police, but it's also uh, bodies like the organizations like the Enforcement Directorate, for example, or the Narcotics Control Bureau. Now, if these authorities get away with doing something wrong, I mean something which is patently wrong, right? It is definitely going to have an impact on society, and that's why I think it's a broader question than the ideological thing. Now, the enforcement directorate, for example, may not necessarily be concerned about ideology. Okay, but they can still get after a person. NCB, they may not be concerned about ideology, but they can still get after a person. Somebody like Riya Chakravarti, for example, right? She was not opposing the government or anything, but they got after her. So once these bodies like the police, NCB, ED, whatever, you know, once they know that nothing is going to happen to us if we do something wrong, then fine, we can take the law into our own hands, and that's when the rule of law becomes, compromised, so to speak. And
Right.
that is what we have to be, careful about.
Right. And you have also at various points spoken about compassion and expeditious justice and access to justice. And compassion is one element which we saw in your uh, uh, term when you were heading the social justice branch of the Supreme Court, which we increasingly find lacking, not only when it comes to, say, disposing of bail applications, but also in various other cases like PILs filed for, say, migrant laborers or people who were displaced because of the overnight imposition of lockdown, and so many other cases. I would like to ask you, what do you think is the future of the social justice jurisprudence in the country? You think the social justice jurisprudence in the country has suffered a setback over the last few years in the way the higher judiciary has over and over again sided with the executive and for one reason or the other failed to give enough succor and relief to the dispossessed and the underprivileged?
Yeah, I think it has suffered a setback. I'm pretty clear about that. We are talking when we talk about social justice in the context of the social justice bench, we are talking about disadvantaged persons, right? Marginalized persons. Now, you had the situation of last year, of the migrants. Now, obviously, on the face of it, they were disadvantaged. I mean, they had to trudge back home. One girl had to, cycle, I think, 1,000 kilometers or something with her father. Right? Now, if the court says that, listen, theek hai, ho gaya, so what if there's migration? Then there's something wrong. You can't just ignore the plight of millions of people. Okay? Even hundreds of people. You can't ignore it. You have homeless people. You have people who are unable to, the cost of this COVID treatment. First of all, going to a hospital, spending money in the hospital. A lot of people have got impoverished because of that. Can you say, well, what can we do about it? We can't do anything about it. You can't look at it, in that sort of a manner. I mean, we don't even treat, prisoners of war in that way. Why should we treat our own people like that? So I think compassion is very, very important, and social justice is very important. But over the years, I think things like the economy or economic justice, as distinguished from socio-economic justice, these have been highlighted.
How do you see the case of Stan Swami, an 85-year-old Jesuit priest, where he had to go to the courts over and over again for something as basic as a sipper or a straw.
Yeah, that's a question of compassion. You know, if I remember correctly, correct me if I'm wrong, the jail authority said there's no provision, there's no rule or whatever in the prison manual which says that you're entitled to a sipper or a straw. But is there a rule which says that you cannot be given a straw? There's no such rule. So if he asks for a straw, why can't it be given to him? Why is it that a negative is used to deny something to a person? Now, what is he going to do with the straw? He's just going to drink water or, whatever he wants to drink with it. He can't start a revolution or something with a straw. That's where compassion comes in. And then you say you go to court. Now, fine, there may be lawyers who have gone, pro bono, who have assisted in pro bono. But supposing a lawyer says, no, you see, I need my fees. And he quotes a figure of, 4 figures for a straw, which you can buy a packet of straws for, I think, about 50 rupees, 100 rupees or something. And what does he want? He just wants one straw. He doesn't want 100 straws. That's where compassion comes in.
Yeah.
Or you have a situation like this Natasha when her father died. Has there to be an argument that, she wants to go, her father has died? There doesn't have to be an argument on that.
Yeah.
That's where compassion comes in.
Yes.
And if that is lacking, then we are in trouble.
Right. And state functionaries, police, specialized agencies, prison officials, sometimes overtly, sometimes indirectly, they trample upon civil liberties and sometimes even commit offenses. Uh, as a former judge of the Supreme Court, as as a jurist, you think that these kind of broad immunities, whether by convention or by law, which have been granted to government officials and state functionaries, are they justified and necessary? And don't they gnaw at the very spirit of the rule of law?
Yeah, I think we have to have a relook at all this. We have to have a relook. Now, if you remember that case of Benny and his father in Tuticorin, who were bashed up and they died, right? What has happened to the police?
Yeah.
It's been about a year or a year and a half. I don't know. What happened to those people who, staged an encounter or there was an encounter? One doesn't even know what happened.
Yeah.
In Hyderabad, when those 4 people were killed, right? What happened to that person who was killed in an encounter or was trying to run away near Kanpur? He was killed. These are instances which are a year old, if not more. Contrast this with George Floyd.
Yes.
Within a year, that policeman has been convicted and sentenced.
Yeah.
And we are still trying to figure out, whether the people who bashed up Benny and his father died. It's not that they were only bashed up, they died. We're still trying to figure out, kya hua?
Yeah.
I mean,
Yeah.
it can't be like that.
Yeah.
So we have to, revisit all this.
Yes.
Otherwise, we're inviting trouble. If we say it's a part of life. It's been going on for the last so many years. Let it go on for another couple of years. But in the next couple of years, that will be the end of it.
Indra, if I may ask you, uh, from your 50 years of long experience dealing with cases of human rights violations and violations of civil liberties, uh, how you think uh, one can ensure that special courts and special procedures enacted under anti-terror laws follow judicial independence and the requisites of a fair trial?
Ashish, I don't think I can answer this question without raising a few larger issues in this discussion. And what I have noticed is that as we speak, goalposts are changed. Now, if you amend the law and say this is not the law, how do you expect a lawyer to go to court and argue, well, this is the law? Let me give you a couple of examples. If you take Article 370 of the Constitution of India, all you need to do is to amend the law and say the state government shall mean the central government. You've changed the goalpost. Throughout your life, you've been arguing that it's the state which will take a decision what is the future of J&K, and suddenly you turn around and say, no, it's the central government. So I can give you any number of examples of this. You take the CAA, okay? I've grown up all my life almost thinking that everybody who is born in this country is a citizen, though citizenship in our country is not only based on birth, but then in a very creeping fashion, you have laws which say, no, both your parents must have been of Indian origin. Then you say one of them, neither of them should have been an illegal migrant. And finally, you end up with a law which says, we will still give you citizenship, notwithstanding the fact that you entered as an illegal immigrant, provided, however, you happen to be a Hindu. So I think there are how does one answer a question like that? Okay, if you want to know my feeling, I can tell you my feeling. I don't have an answer, but when I started my practice as a social justice lawyer, I was under the impression that one just has to argue for social and economic rights, and this country will be in a state of paradise. If we can just eliminate poverty, that's our only problem. But today, if you ask me the same question, I will say, I'm sorry, I was very mistaken. What I need more than my economic and my social rights is my political and civil rights. And because why? Because your civil and political rights gives you the right to speak up. Right. And I think that the people we are talking about, whether they are marginalized or whether they are political dissidents, they have only one weapon in their armory, and that is their voice. You take that away and you have taken away their life. Okay. There is nothing left to argue for. Then you can give a person as much food as you want. You can give that person as much clothing and housing as you want. But if you don't give them the right to speak, you have achieved nothing. So I think we need to understand, why is it in this country that the goalpost is changing all the time? Why is the secular character of the country being dismantled brick by brick? And unless we have an answer to that question, I don't think we can, people like me who are not in the judiciary on the other side, my tools for advocating for justice are being taken away systematically. And then what are you left with? You're left to the mercy of the Supreme Court. Now, we are not supposed to be left to the mercy of the Supreme Court. We are dependent on the law. And the law is a tool. It's a very powerful tool in our hands. So I would argue for the return of that tool. As we speak, Ashish, Justice Lokur is surely aware of the fact that the Bar Council of India has just issued rules to say that you can't criticize the judiciary. And if you do, you'll be disqualified as a lawyer. Now, how can I answer your question, Ashish? I have no answers.
Yeah. To be left to the to be left at the disposal of the Supreme Court. If I can go back to Justice Lokur, which is a new trend has emerged over the last few years, which is the tactical registration of FIRs. Something you say, something you write, and then different complainants in different parts of the country, they register an FIR emanating from the same act or same article that I wrote. Again, the Supreme Court has dealt with these kind of tactical registration of FIRs or this kind of abuse of territorial jurisdiction also in a very uneven manner. So again, Justice Lokur, you wrote an article where you contrasted the Arnav Goswami case with the Amish Devgan case, and those two cases also with other cases where there was not a relief for many other people who were on at the receiving end of those complaints. So how do you deal with this new pattern that is emerging in a country, that a writer, an author, an activist is susceptible to facing simultaneous prosecutions, possible prosecutions in different parts of the country for something as simple as writing an article.
Yes. Again, that is an area that has to be looked at, right? And it's not only territorial; it can be a multiple FIRs. For example, you write an article in Delhi today, all right? Somebody is unhappy with the article, and let me tell you, this is not something which is new. It is something which has happened in the past. So you write an article, and somebody, in the Northeast, files an FIR against you. Okay. Now, according to Delhi police, it takes 3 days to go by Rajdhani from Delhi to Guwahati. That's what the Delhi police told the trial judge when they wanted to verify Devangana Karta's address. So somebody files a case against you in some village or some district of Nagaland. Another person files something against you in Jammu and Kashmir. Somebody files against you in Kerala or Lakshadweep, right? Where it's not easy to go. Somebody in Andamans. Okay, now should that be permitted? So this is something which has to be looked at. Now this is sheer harassment. The court, the police says you come. Now you can't go to all these 6, 7 different places. So you have a problem not only of territory, but you have a problem of multiple FIRs filed against you. Now, when I said this has happened in the past, there was a time, under the Negotiable Instruments Act, the check is bounced.
Yep.
Right? Now, somebody in Maharashtra, for example, or somebody in Karnataka, for example, gives a check which bounces. This person opens a bank account in Sikkim, right, and gets a notice issued from Sikkim and says you come to Sikkim. Now, should that be permitted? So we have to look at these laws because today many of them are being procedural laws. Many of them are being misused, if not abused. So we need to have a fresh look at many of these things, right? So I think this whole business of writing articles and 10 FIRs being filed against you in 10 different parts of the country is nothing but sheer abuse. How many people can actually go to the Supreme Court and say that, listen, there are 10 FIRs against me and you please club them and send them to one place?
Yeah.
Everybody can't go to the Supreme Court. Okay. But now I think what has happened, which I think is very, very interesting. There was some person who was summoned by Delhi police a few days ago. He said, I'm not coming. All right. So the Delhi police said, you go to his house and you question him over there, interrogate him over there. So they went to his house and they interrogated him. Probably the interrogation was not complete, whatever, I don't know. Then now the police say, all right, now you appear before us through video conferencing. Okay, very good. Now, Karnataka High Court has also passed a similar order with regard to the chief of Twitter in India, that the police in UP can examine him through video conference. Do that. Then the police will also come to their senses. So you don't have to bring Disha Ravi from Bangalore to Delhi to question her. It can be done through video conference.
Yes.
Right? I think this is something which people should take advantage of. That if you want to summon somebody and interrogate him, do it through video conference. Let's see what happens.
Right. And I would just like to end this conversation, Justice Lokur, with one final question, which is before the judiciary, especially the higher judiciary, some very profound questions of credibility are looming large, especially when large number of people in this country, they believe that the process of justice is very uncertain, expensive, and torturous. You think, as a former judge of the Supreme Court of India, do you feel concerned about the diminishing faith in judicial relief that a common man expects from the highest courts of this country?
Uh, I do feel concerned, certainly. Certainly, I do feel concerned. You see, it's like this. Uh, the judiciary has had bad times in the past, all right? But there has to be the will to bounce back. And unless that will is shown by the Supreme Court, things may not improve. And let me tell you, after the emergency, the Supreme Court bounced back pretty fast. The emergency was over in 77. In 79, we started getting these judgments of, Lokur standi being relaxed in SP Gupta's case. You had public interest litigation. It took 2 years, or maybe less than 2 years, for the Supreme Court to bounce back. But there was a will at that time. I don't know whether today there's a will or there is no will. If there is a will, perhaps the Supreme Court can bounce back. But if it is a chalta hai kind of attitude, there's a problem.
Yeah. Indira, if I can come back to you for one final question. As a civil rights lawyer with 50 years long practice, what do you think is the role of lawyers like you to ensure that judiciary is one alive to the ground reality and is also alive to the need of a very expeditious and effective relief to people who have been wronged by the state? What role do you think lawyers like you can play?
Um, it is no longer possible to play a role only inside the courts. I think advocacy for civil rights has to be done inside and outside the courts. Yeah, and so that's one. So that's one way in which I think we can move forward. Because, as I said, at the heart of this debate is a political issue. What is the idea of India? Do we want to see an India which is where secularism is being dismantled, and or do we want to fight for the preservation of secularism, whether it's inside or outside the courtroom? I see that as a major role of civil rights lawyers, because it's only in a secular framework that people like us will get justice, not in a framework which has a judicial Hindutva state would make it impossible for any rights adjudication to take place, because in that case you don't need a court, right? Your rights are then guaranteed by a government, and you don't need a court to go to. So that is one role that I see. And of course, the other is to inside a courtroom, to keep raising these issues without fear. I think, look, there is a major problem with the way the legal system functions. First, there is in the judiciary and in the legal profession the institution of dynasty. Okay. The second thing is that most lawyers seem to think that their success depends on their finding favor with judges. Now, here is where I think that the legal profession needs to undergo a role change. And a direct answer to your question is to argue fearlessly, politely, and in a dignified manner before a judge your point of view without worrying that you're going to lose your case. I would suggest no compromises be made on what you see as the proposition of law, as the correct proposition of law, and not just end up with ad hoc orders. The ad hocism in the judiciary has gone very far. And I must say that I don't enjoy arguing my cases in a court of law in an ad hoc manner. I think in the future, It is your skills, your forensic skills as a lawyer, grounded in constitutionalism, which is the way forward for civil rights lawyers in this country.
Thank you so much, Justice Lokur. Thank
Thank
you,
you.
Ms. Indira, for speaking to the leaflet and for this very illuminating and informative conversation on uh, accountable jurisprudence, on compassionate jurisprudence, on the rule of law, and a very, very topical issue, which is of uh, the anti-terror and security laws and their uh, possible misuse and misapplication. I believe that there is no other area of law which is being more vigorously contested and debated than the issues related to law of sedition and UAPA. The Supreme Court of India has finally agreed to hear the constitutionality of Section 124A, which is a law of sedition all over again. And I believe that the 2019 amendment of the UAPA is also under challenge for its constitutional validity. So we'll hear more from the Supreme Court, more from noted jurists like Justice Lokur and Indira in the coming days on issues of human rights and civil liberties and their interplay with the laws of the land. Uh, Hope to see you soon in one new episode of Leaflet with where we'll be talking on a similar issue of public importance. Thank you for watching.